Welcome to the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to another episode of the Dealmaking with Laura DiFrancesco podcast. I'm really excited today to be talking to you about the seller's perspective on due diligence. Oftentimes, due diligence is thought of solely from the buyer's perspective, but really there's a lot that the seller needs to think about, and actually that the buyer should think about as well, because being conscientious in a transaction and being aware of another party's interests, concerns proactively can really help mitigate any bumps in the road, which can really facilitate a much smoother deal-making process, both from the beginning all the way to the end. So let's talk about a few key things that a seller will be thinking about going into the due diligence process. So number one concern is confidentiality. That is why sellers start with non-disclosures agreements. So we want to make sure from the seller's perspective that the non-disclosure agreement is actually going to be serving you, and it's not just, a blanket, that something won't be disclosed, but that also that it won't be used competitively against you, or that your employees won't be solicited and whatnot, as well as making sure that the scope of what's considered confidential information is well defined, and also what the exclusions are and rights of the buyer or other parties receiving this confidential information are to be sharing that information, using that information, having obligations to destroy that information once the deal conversations end, to the extent that they do. And then, of course, the duration of those confidentiality provisions. So I actually, funny enough, spent all day so far working on different confidential information agreements. A lot of people would think that the confidentiality agreements are just these standard boilerplate documents that no one needs to think about and you just sign. You could not be more wrong, because first off, a business's confidential information is the heart and blood of a business. It is the value of the business itself. And so it's very important to take these into consideration. And also, your confidentiality agreements wildly differ depending on the situation. One person asked me for a confidentiality agreement. They told me how they wanted to use it. And I said, hey, we're actually going to need 5 different confidentiality agreements because you just told me 5 different ways that you want to use this confidentiality agreement, and what our concerns are, how we define things, what our obligations are, and what we want to include in those confidentiality agreements are going to be different from agreement to agreement based on the different scenarios. The next is going to be access to personnel, access to the facilities, and what is that scope of due diligence that's permitted. Generally, this is going to be set forth in the letter of intent to be clear that the parties agree what is reasonable scope of due diligence for the transaction. From a seller's perspective, oftentimes they're going to be concerned with making sure that conversations with employees happen after a purchase agreement is signed. That's a pretty reasonable time period, but before that might be putting the cart before the horse. In addition to that, most sellers are going to be very concerned about giving access to vendors or clients prior to the transaction closing. Again, that might be something after a purchase agreement is signed, but not in the beginning, 5 days after a LOI has been signed. So those are a few key things to make sure that the existence of a potential sale does not in any way diminish the value of the business. In addition, the seller should be really focused on preparing documents for the buyers to review. Well before they enter into a letter of intent, they should be going through all of their potential due diligence documents, making sure that they're organized, easy to respond to. When a buyer is under letter of intent, they have a clicking timeline, they're spending money rapidly. They want to make sure that they have quick and easy responses to information requests. From a seller's perspective, it's going to feel like you're being bombarded with questions, probably more than a lender has asked. And that's normal. It is normal for those requests to be made, but you should be talking with your attorney to confirm, are these requests normal? Is it an appropriate time of the transaction? And of course, if you're a seller preparing your business for sale, the best time to start working on due diligence is before you start actively marketing the business for sale. We do a pre-sale due diligence preparation where you can identify some key risks within the business, if it's contracts or employment agreements or potential liabilities or whatnot, and we can talk about how to minimize those so that it doesn't impact the potential returns on your investment by selling your business. You don't want something coming up in due diligence being an issue that you have to renegotiate the deal for. And that could be very, very expensive from a seller's perspective. So working with an attorney before the business is actively marketed, or as soon as you're marketing it, at a minimum before LOI or immediately post LOI, we like to send you what to expect, what documents to start organizing, insurance, financial documents. You don't have to give access to QuickBooks. You can export all of your financial data, and making sure all of these are well organized in what we call a data room. A data room is where we store all of your confidential information with different access permissions based on those who are granted. And then, of course, if conversation stops, that access is removed immediately so that you have protection for your confidential information. So we'll start talking to you about getting that information organized at a minimum on your side so that you are prepared for the number of questions that you'll receive, and making sure that the answers that you provide are clear, up to date, accurate, and comprehensive, but not overly responsive. So there's a very fine line between being responsive and responding to something that wasn't asked. So as a seller, you want to be careful about what information you're sharing and only share the minimum necessary. When you have those documents organized, it will vastly accelerate the due diligence process. It will vastly accelerate the amount of time between closing and now. So the more that you're organized going into this process, the better the process will be for you, both from a value perspective, time, stress, and it'll also show a very readiness to sell the business and professionalism. So all of those will be really good. It may be difficult organizing these documents, locating these documents. They could be from 20 years ago, some of your organizational documents or more. So that's why it's important to get an early start on this. And we can also help you with organizing it and showing you where to put things and everything. And then if there's any sensitive information, we will go over whether it needs to be redacted. For instance, employee social security numbers don't need to be provided. And if you are very sensitive about information regarding employees, you can redact names until a purchase agreement is signed or something like that, or further when maybe a purchase agreement is provided. Ideally, all of this should be included in your letter of intent, but those are a lot of proactive scenarios and solutions that we can provide to be able to make a seller more comfortable. And of course, if you're on the buy side and your seller needs representation, we are happy to be considered for representing sellers. It's something that we do very often in our process of mergers and acquisitions, representing buyers and sellers, buying and selling businesses. Now, when you have well-prepared documents that are organized, it'll really reduce friction as much as possible and position the seller to be very credible and reliable. That is a really important stance to be maintaining throughout the due diligence process so that there's trust and it continues to foster a productive and successful deal-making atmosphere. If there are any big gaps in documentation, that may raise concerns or that may potentially even derail the deal. And that's what we want to avoid. That's why getting all of this organized at the beginning, at the outset, before perhaps you're even actively marketing the business, is the best possible scenario for you. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion-dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. And then in addition to that, we work with sellers in helping to anticipate buyer questions. So we'll ask about the most often asked questions so that you're starting to think about these things, preparing responses. And while there may be a situation that needs to be disclosed, how it's disclosed can vastly impact the direction of the deal. So if there's a potential liability, but we're able to preface it with, we know how much that potential liability is capped at. It's this amount. It's covered by insurance. It's really a non-issue. We are sharing it with you, of course, and we're going to include it in our disclosure schedules, but it's really a non-issue. And if it makes you feel more comfortable, the seller will add it to the indemnification. So, how you have a response can definitely shape how the deal continues to move forward, because a response that's not only well thought out, but positions you well. In addition, that's going to build confidence from the buyer, knowing that they feel that the seller knows the business, has control over the business. It has clear documentation to back up their positions and answers and everything. And it'll really also give you an opportunity to highlight your strengths during due diligence. So how you respond can be both just flatline answers, or can really highlight your strengths and continue to sell the business, because sometimes you need to continue selling the business all the way till closing. When we work with you to anticipate those difficult questions, those challenges that are going to come up, that really enables you to maintain the value of the business. And it also builds transparency and balances out the relationship. So one of the biggest reasons why buyers are interested in due diligence is because there is an abnormal amount of lack of transparency in any sort of business. The seller can know everything. They have all the answers within their head. The buyer's using this as an opportunity to really start to get to know the business, how they need to transition the business, what they can do after the business, where the weaknesses and strengths of the business are, whether the business is what they actually think it is. All of these are really important aspects of the buyer's considerations when they're going into the due diligence process. And then when you're able to reduce that uncertainty and move the deal forward, that propels you into success for transactions closing, which is going to make the likelihood of closing even more likely, which is really a key important aspect that the seller should always be thinking about, is deal momentum. Oftentimes, sellers can be overwhelmed and flustered by the amount of questions received, but maintaining positive and strong deal momentum maintains your likelihood of getting to closing. How terrible would it be to go through all of these processes but be responding in 2 weeks or 3 weeks or 4 weeks to due diligence responses, and then the buyer's losing confidence in the deal, the buyer's not able to respond to their vendors, their lender, their attorney on information that they need, their financial due diligence provider on information that they need to be able to document the transaction, get to closing. So delays are really easily avoidable with good preparation, and it continues the positive momentum of the transaction. So if you're thinking about timeline, what is the appropriate response timeline? Ideally, you want to be responding in 1 to 2 business days is the goal. I would say 5 business days should be the maximum. And sometimes in the really hard things, when you're asking third parties, if there's anything you need to ask your accountant for, your insurance company for, anything like that, start that right away, because it may take them some time and you need to build that into your response timeline. But the goal should always be responding to all of those questions within a week. That really prepares you for a solid position going into the closing process. And then, what due diligence should sellers conduct on buyers? Sellers conducting due diligence on buyers is actually something that's little known but very important, especially where a seller note is provided. It's important to ask conversations about what is the buyer's organizational documents, who are the owners, are there assets of the business, or if there's a guarantee or personal guarantee provided, which is not always typical, but may happen here and there, or if there's security agreements or UCC financing statements, securities, mortgages, all of these things. You have to ask a lot more questions as if you're a lender. We support our sellers throughout that process, asking questions. And sometimes it's definitely not nearly as much of questions that the buyer's asking, but if the seller is the sole lender on the transaction, it's probably going to be about half at least of the questions that the buyer is asking that the seller will need to ask as well, because the seller needs to be doing their own underwriting as well. If the buyer doesn't have a dollar to their name, how are they going to withstand the ups and downs of business? As you, as the seller, know, there are a lot of challenges in business, and sometimes you have to tap into your personal pocketbook to finance payroll for the month because who knows what happened? COVID, supply chain, all of these things that just happen that as entrepreneurs and especially as a lender, you need to make sure that the business can continue going forward productively. Of course, some of this information is necessary just to be able to move forward with the transaction. Organizational documents, owners, making sure that there aren't major liabilities that the buyer has. Those are really important just from perspective of moving forward and documenting the transaction. But overall, buyers may be just as hesitant to share sensitive information as sellers are. So it's important to go through that process with compassion on both sides, but also have sellers lean onto their lawyers to be able to know what questions to ask. Likewise, for buyers, leaning onto lawyers as to what questions they need to ask. The goal with due diligence on both sides is to minimize the risk of failed transactions. That's the goal. It's not to act like there's no skeletons in the closet for any business. You're going to find something somewhere always, but the goal is to know what it is and for your attorney to be able to help you navigate what that challenge is, help you structure it in the transaction documents, address it so that it's a non-issue or at least an anticipated issue with a solution. And then part of that due diligence on buy side and sell side is a just overall understanding buyer fit, understanding seller fit, making sure that you both are the people that you want to do business with. Sometimes sellers have gotten to almost signing the deal documents and they're saying to me, what if this is fraud? Do you trust them? And that's not, I can say that we've done the due diligence. I can say questions we can ask. I can help navigate those. But ultimately, both buyers and sellers need to be doing those regular gut checks throughout the entire transaction so that it doesn't get to the end, and making sure that they feel comfortable doing business with the other side. A well-aligned buyer-seller fit can really have a proactive relationship post-closing, because there are a lot of different things that the buyer and seller generally have to collaborate with to transition the business. And then overall, the due diligence, the impact on the acquisition, one, it tends to be a gating item. It tends to be something that prevents other parts of the acquisition moving forward. You can't document the deal through a purchase agreement or ancillary transaction documents when the parties don't have an idea about the structure that needs to be set forth or the provisions that need to be set forth to address the uniqueness of the buyer and seller and their fit together. And overall, the goal is just to be proactive, professional, and responsive to questions that are being asked on either side. When you're able to find those red flags and address them proactively with your attorney, you're able to set yourself up for success, both buy side and sell side. It'll increase confidence on the other side, enable you to navigate complex challenges without derailing the deal or spinning it off or adding another month or whatever the case may be. So whenever you're able to work proactively through due diligence, you're able to really put forth a commitment to the other side that you are interested in moving forward. And that demonstration of commitment, it can save you tens and tens of thousands of dollars in the near term and hundreds of thousands of dollars or millions of dollars, depending on the situation, in the long term. So you want to make sure that it's not going to financially impact you and you are prepared for success. I hope that this has been helpful. If you have any questions, be sure to leave them on our show through Spotify. You can leave them in the comments. Be sure to leave us a 5-star review. Let us know what episode you'd like to see next. And thank you so much for joining us on another episode of the Dealmaking with Laura DiFrancesco podcast. Thank you so much for joining us on this episode of the Dealmaking with Laura DiFrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please be sure to follow and subscribe to Dealmaking with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please leave a 5-star review. It would mean the world to us, and share this podcast with your network, friends, and colleagues. For more in-depth resources, be sure to visit our website, deanstreetlaw.com, where you can find articles, guides, and more information on our services. Don't forget to follow us on social media for the latest episodes, updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Join us on our next episode where we'll explore more deal-making insights. Cheers and happy deal making.